Hi, everyone. Welcome to another episode of the Ask Amity Show. Today, we'd like to talk to you about the 3 estate planning documents to update if you're getting a divorce. The problem is if you're considering a divorce or in the beginning processes of getting a divorce, you should review your estate plan if you created one during the time you were married with your spouse. So certain situations, when you originally created your estate plan and you were married, then most of your documents would most likely have your spouse listed somewhere to help make certain decisions on your behalf, such as if you become incapacitated or become disabled. And so we would suggest before finalizing your divorce, your estranged spouse may have certain control over you and your estate. So 3 documents that you should especially pay attention to and make changes are.
So the first document is your will. If you created a will before your divorce, California law provides that any provision in the will for the benefit of your former spouse is ineffective. So in California, the will, if it's not revoked, it is interpreted that if your ex-spouse, in California, the will is not revoked, it is interpreted as if your ex-spouse had predeceased you. So meaning if you had a will and you named your ex-spouse as a beneficiary or an executor and you've been divorced, then the law in California states that all of that is invalid as to your ex-spouse. Your former spouse has no rights to your estate, either as a beneficiary, an executor, or an administrator. The rules of the law apply only to the ex-spouse. So if your will makes provisions for the ex-spouse's children, or other remote issue or other relatives of your ex-spouse, and is not wholly revoked by the divorce, these provisions in the will still stand. The divorce has no effect on these other people. If you made a will before the divorce and indicated in the document that you intended that the provisions for your soon-to-be ex-spouse to be valid after the divorce, then your announced intentions overcome the law. So you really need to be very intentional about naming an ex-spouse in your trust or in your will. If you get a divorce and you still want your spouse to be a beneficiary or an executor, make sure that you create another will after the divorce, naming them and making your intentions clear.
Yes, and then the next document really to pay attention to is your living trust. So usually, in your living trust, you would name your beneficiaries, your trustees, who's going to be in charge of your estate at the time of your death. So if you pass away during your divorce and before it's finalized, and you leave everything to your, soon-to-be ex-spouse, that's who's going to get your estate. So you have to make sure that if you are, in the process of getting the divorce, we would suggest that you take a look at your trust. Either you can revoke it at the time if it's a revocable trust, or if you do have an irrevocable trust, many times we also want to keep in mind, whether or not divorce is perhaps in the horizon or you're concerned that that could be a possibility. Then we can have within the irrevocable trust, since it is irrevocable, you can't really make changes to it upon the divorce happening. So you want to make sure to specify within that irrevocable trust during the time you create it that a divorce will remove current spouse as a beneficiary, and that when used in the document wife or husband, it means whomever you are married to and not a specific individual. So that's something you can specify in an irrevocable trust. For revocable trust, which is the more common of the trusts most people would create just for avoiding probate and just having beneficiaries listed for their estate plan. And then with that document, we would suggest going into it, making changes to it, make an amendment to make sure that you remove your soon-to-be ex-spouse as a beneficiary or any sort of trustee. So that's really important to make sure that you do make the living trust those changes to it before the divorce is final, just in case something does happen to you during the divorce.
And the last and final document that you really want to pay attention to is the power of attorney. So if you have a signed power of attorney giving your spouse the authority to act as your agent, in California, this grant of power is revoked when either spouse files for an action of for divorce. Until the divorce is filed, the spouse can continue to act using the power of attorney. This can be a very dangerous power. So unlike the will, the provision naming the spouse as a power of attorney is usually revoked when the divorce is filed, not when the final decree occurs in the divorce. When a divorce action is filed, only the appointment of the spouse as an agent in the power of attorney is revoked. The whole power of attorney is not revoked. So if you named a successor, the successor in that power of attorney can still serve. In the case of a remarriage, the power of attorney is automatically reinstated, revises the same provisions of the spouse's will. So if the power of attorney includes an appointment of the spouse as a guardian, so now we're talking about guardianship and the appointment of a guardian for the children. If a court-appointed guardian is necessary, filing for divorce does not revoke that appointment. So instead, a court would have to decide if filing for divorce is a good reason not to appoint a spouse as a guardian. When the divorce becomes final, however, the appointment of the ex-spouse as a guardian is then revoked. So again, we can continue to have this conversation a free consultation that we offer to anybody who wants to talk about these topics and anything that relates to probate or estate planning. Feel free to give us a call and we'll be happy to speak to you. Again, remember to subscribe to our channel so you can get notifications on more videos like this. And that's all for now.